Our next speaker on the topic of jury selection and cross-examination is a 87 graduate of Amherst College and a 1981 graduate of the University of Miami School of Law with JD with honors. He's held leadership positions in the Florida Bar, serving as a member of the Board of Governors and past president of Young Lawyers Section. He served as a member of the Board of Directors of the Florida Justice Association. He holds AD ratings from Martindale Hubble and is also consistently listed in the Best Lawyer magazines here in Florida. He's a frequent lecturer at CLEs throughout Florida on trial practice, catastrophic injury litigation, and consumer advocacy. He's also a member of the multi-million-dollar Advocate Forum. He's been involved in dozens of seven-figure settlements and verdicts and numerous eight-figure settlements and verdicts. Chances are, if there has been a significant medical malpractice settlement or verdict in the past 10 years, our next speaker has been involved in it. As Mr. Diaz was mentioned as the go-to guy for defense insurance companies, our next speaker is the go-to guy for those who are catastrophically injured. His litigation skills are now in demand throughout the country as he currently has cases pending in Texas, Louisiana, Alabama, as well as here in Florida. I met your next speaker when I was a defense lawyer. I quickly realized I had going against me perhaps the finest plaintiff's lawyer I'd ever been against. He had an amazing command of the facts. He knew the medicine. He obviously knew the law. He definitely knew the strengths of his case and, more importantly, knew the weaknesses of mine. He is tenacious. I've seen him try 5 cases to verdict, and there is no better trial lawyer anywhere. So I'm pleased to introduce you a person I once feared as an opponent, but now a person I'm proud to call a friend and a boss, Stuart Ratzan.
Hopefully this is on, yes. There is no perfect trial. There is no perfect trial lawyer, and there is no perfect way to try a case. So if you're in search of the Holy Grail today, if you're in search of all the answers of how to do it, I don't have them. Roy doesn't have them. No one on our panel has them. But why we're here is because of the love of learning, the love that I have for trying cases, the love I hope that all of you have for what we do, that we can come together and learn how to be the best that we can be, and how to try the best case that we can try. I want to digress and thank all of you. I am Stuart Ratzan, and I've helped put this seminar together. I want to thank all of you for coming here. It's a great forum, and it's a great opportunity for us up here to learn, not just to share and teach, but all of us to learn and make the practice of law, those of us who are taking on the burden of being a trial lawyer, to make it better for all of us, because it's a tough way to make a living, I got to tell you that. I have scars. Roy Diaz is responsible for some of those scars. I haven't won every single case I've tried. I've lost, and I've had hung juries. And it's those scars, the bruises, the injuries that we have to our psyche as trial lawyers that make us really better lawyers. I think I'm getting better. The first time I tried a case with Rolly, it was 5-1 against me. This time it was 3-3, so one day, eventually, I'll get there. But you can see why he's such a good lawyer and why it's tough to be a medical malpractice plaintiff's trial lawyer. Because going up against you not only are certain jury biases and things like that, but there are very fine lawyers on their side. And I'm glad that Rolly spoke about a lot of things he spoke about, because what he talked about with respect to breaking down the walls of his defendant doctor, who may be arrogant or full of ego and incapable of really being what he or she needs to be in a trial. And I saw him do it, and he does it. That's what I want to talk about for you. I have an ambitious program today with jury selection and cross-examination. And trying cases can be really scary stuff. And if there's anything about trying cases that's the most scary, it's probably those two things. And I remember the first time I tried a case. Standing up to pick a jury, where there's no script, there's no, you haven't worked with a witness for hours and hours about the 5 things. You have to talk to a group of people back and forth and do something with that and get to the honest truth with those people who you've never met before. And it could be a room, I've spoken to rooms as big as this, 50 to 70 jurors at once, and had to go into the room and ask each of them and get information from each of them that's relevant to their ability to serve on a jury. That is scary stuff. And cross-examination, where the witness who's maybe a skilled, trained, expert witness who maybe you've never talked to because someone else took their deposition. And you have to get from them meaningful pieces of information that's going to help your case. How do you do that? You didn't get to meet with them for 5 hours either. And you didn't go over 5 things with them either. So how on earth are you going to get from them what you need? If there's 2 things that are the scariest part about trying cases, I think it's those 2 things. And it's also those 2 things that make the whole difference in the case, in my opinion. I think jury selection may be the most important thing in the trial, but cross-examination of the critical witnesses on their side, just the same. So it's an ambitious program that I've chosen for you, and we'll go through it. But the essence of what I'm going to talk to you about are not the skills. I don't have time to go into the minute-by-minute skills of how to do each thing. I can talk to you about it generally. We could spend a week on each topic, and we could have breakout sessions, and we could all get into it and we get better at it, no doubt about it. But I don't think, and this is now to you from the bottom of my heart about trying cases, I don't think any of us can be good at it or be successful at it unless you do some of the things that Rolly Diaz was telling you about with his client, that you do those with yourself. So what do I mean by that? And I have this is basically what is in your outline, but it'll help us all stand on track. I call it the trial lawyer's riff, meaning Keith Richards was a great lead guitarist for the Rolling Stones, and he talks about the riff. Can you hear that? Anyway, that's a riff. That start me up. And he's a phenomenally trained musician. He's learned how to play all the chords. He grew up in new music, and then he became a rock and roll star, and he got into the riff, where he let himself go, and he sat there, and they would sit around. I read his autobiography. Sit around with Mick Jagger, and he'd come up with chords and ways to create a riff, just not by following the notes, not by sticking to a rigid method from music school, but just out of his heart, out of who he was, and who he and Mick Jagger were. How do you get to that riff is how to be a successful trial lawyer. And the best places to do it are jury selection and cross-examination, because those are the 2 places where you have the least amount of control in your trial. And that's why they're the scariest, but when you hopefully learn to do what I believe in so strongly, then the riff comes out. And it becomes not the scariest thing anymore, but the opportunity. The place where you get to what I call the magical moment of a jury trial. So, you'll see in your outline I talk about this first off. Be who you are. What does that mean? I mean, we could spend, it's beyond the scope of this, but we could spend a lifetime, and most of us who try cases do this, trying to discover who we really are. So when Mr. Diaz talks about that with his witness, that, break down the ego. Who are you? Where'd you come from? What are you about? Why are you compelling? It's not why you're such a great doctor, why you're so famous, why you're going to buy your Porsche, why you're going to do all those things. Jurors don't care about that. And for you as a lawyer, if there's anything that's going to hurt you, it's all that you've learned in college, all you learned in law school, how you dress up in fancy clothes, and how you put walls around yourself to be someone other than who you really are in a courtroom. I read books about trying cases. I don't just try them, I read books and I crave information. If you could read anything by Rick Friedman or Jerry Spence, go to the bookstore, Run, Don't Walk, and read it all. Rick Friedman wrote On Becoming a Trial Lawyer, Polarizing the Case, and Rules of the Road. Jerry Spence has written all kinds of things, how to argue and win every time, how to win your case. They discuss this better than anybody who I've ever read. What does it mean to be who you are? It means forget about the fact that you speak with fancy words and forget about all of your fancy education and your smart clothes. And be a real person. And if you're fearful, that's normal. And when you stand in front of people and talk to them and try to get the information from them, those walls that you have, just like for the defendant in the malpractice case, those walls that you have need to come down. Because what jurors care about is not whether, and this is where I divert a little bit from what other people say sometimes. It's not wanting them to love you. If you're in a courtroom and you're sitting there, do they like me? Do they think this ear sticks out? Does my tie fit right? Is it matching? If you're sitting there going through all that stuff, and does he like me? Did he think I was funny? Does she think I'm nice looking? All that kind of thing? Get rid of it. It doesn't matter whether they love you. It matters whether they trust you. And they know you're an advocate, so they know you're not going to be telling them things just in a non-biased way. But are you a reliable source of information? That's what counts. That's it. So you cannot be a reliable source of information if you're not credible. And if you're trying to be anybody other than who you are not credible. And I'm telling you something, I don't care what the tort reformers think and what the people out there think that don't know anything about our system. There is no better group of people than 6 jurors to sniff out the truth. And the first thing they're sniffing is you. And if you're anything other than who you really are, whatever that is, whoever that is, they're going to sniff it out. And you're no longer a reliable source of information. That means, for my associate Scott Pazina, don't try to be me. When I was younger, don't try to be the guy. People do it all the time. They want to reproduce someone else's success, or they want to reproduce themselves as that other person. Stop doing that. Figure out who you are and be who you are. I don't know how you, whatever it is, whatever it takes to do that, do that. Trust. That's the number 2 thing that I believe heavily in. And what do I mean by that? It's one thing for the jury to trust you and to see you as a reliable source of information. But until you trust the jury, until you really, really, truly, Johnny Edwards talked about this, and he's had a lot of other problems, but as a trial lawyer, he was phenomenal. He trusted the jury. He believed that they could and would do the right thing if they were given the chance. Not because he was sitting there talking about them loving him, but because they've sworn to do a job and they've come in to do that job. And they intend to do it well. Trust them. And when you're talking to them in jury selection, some of them are going to be tort reformers. Some of them are going to be just impossible to deal with and they'll hate the system. Some of them will be completely biased for you. Maybe it's a medical malpractice case and they've been the victims of medical malpractice before. All of those people are decent people. You have to go in there believing most people are mostly good. And you have to trust them. Because you need to find out who's against you. Who's not a fair juror. That's the main mission of jury selection. The number 1 most important thing, and I think the main issue that you're there to do. What can you do to trust your jury? So that when you speak to people, they give you honest answers. Convince yourself, persuade yourself, get deep inside yourself and know your own imperfections, this goes back to the first part, your own limitations, your own prejudices, your own biases, and you're a good person. You intend to do the right thing. So someone who disagrees or someone who sees things differently, they are too. Trust the people you're talking to. Be real people. Be real with them. And then you're ready.